Hi everyone, very good evening. Welcome back to session 2 of non-disclosure agreements. And today we are going to understand about obligations and exceptions of parties. We're also going to talk about trade secrets as well as non-compete clause in your NDA. We are going to talk about types of non-disclosure agreements. So I believe that most of you have attended yesterday's session, that was day 1. Do let me know in the chat box from where you are joining, and did you attend last session or not. So do give me a certain reaction so that I know that you guys are there. Remember that we have few points in order to go ahead with this session. You have to be very much, active in the chat box or in comment session. You can ask me all your queries during the session. So do let me know whatever doubts or queries you have. All right. Without further ado, let's get started. Let me just know. Confirm once the screen is visible to you. And do let me know from where you guys are joining. Okay. You can mention it in the chat box and everything. I'm just quickly going to take you what we discussed in the last session. So, in the first session, we talked about your what is non-disclosure agreement, importance of non-disclosure agreement, and everything. I hope the screen is visible. Can I have your reactions? Any reactions from your end? People who are joining for the first time, let me introduce myself. My name is Ria Chabra. I'm a corporate lawyer with 5 plus years of experience. I've worked with multiple companies such as Infosys, Bright Night, and each company from different sector. I've worked with IT industry as well as with electric industry as well as with contract management industry. And with that experience, I'm going to bring in you what is the importance of non-disclosure agreement. This is one of the most major agreement that is used in every industry, whether you are working in any type of corporate sector, whether you want to work as a freelancer or whether you want to practice in court. As a lawyer, you should be aware of non-disclosure agreements because you will be demanded for this agreement anytime in your career. Plus, there's an advantage of learning about non disclosure agreements while you are still in law school. The benefit is that you'll start earning at early stage. The earlier you start learning about drafting, you'll start earning because in order to become like a contract lawyer who has specialty in drafting contracts, you don't need to have a bar license. You can directly start. All you need is you should be having knowledge about law. You should be having knowledge about how to draft a contract. It's good to see that people are here who were there yesterday as well. Mark your attendance in the chat box. How many of you were there in yesterday's session? If you're joining for the first time, do let me know so that in between the session, if I'm covering something, I'll be able to rebrief you about the details. Okay. And do make sure that you're checking the yesterday's session as well. You can check it out on our YouTube channel. Okay, now there are few rules only that you have to be very much interactive throughout the session. Keep on giving me certain reactions or drop the things in the chat box if you're not understanding something. If you're understanding everything clearly, that's also good. I'll be able to know that I'm explaining things to you very clearly. Okay, all right. Now, NDA, the basic starting range of NDA as a fresher, you can charge around 2000 to 5000, and it all depends on the thing for which you're drafting NDA. So, based on the context and the requirements of the client, you can charge up till 20,000 and beyond just for a non disclosure agreement. So, if you have your skills on drafting, if you have a proper understanding of how to draft master service agreement, franchise agreements, and all, if you become pro in drafting, you can have your own career started before even you graduate from your law school. So, drafting is that important skill. And wherever you go, wherever, be it you're applying for any internship or any job opportunity, if you say that you are aware of how to draft contract, the questions will be coming across what are the things required in each particular agreement, what are boilerplate clauses and all. They'll ask you questions related to that, and then your job will be secured. Reason is many people today are still not aware of how to draft contracts. Just having a college degree will not help you in today's world. You need to have several other certificates as well that are proving your skills. So work on your skills. Irrespective of the fact from which college you are, college name doesn't matter. There's a myth in law college that you should be from a tier 1 law college and all. It's not like that. If you have the skills, you are the perfect candidate. How much score you scored in your law school exam, that also doesn't matter in actual world. What matters is, do you know how to work? Do you have the required skills? That's all. So work on your skills. Now let's get started with our today's topic. So in the last session, we already covered about your what is NDA and all, the importance of non-disclosure agreement. And today we are going to understand about your what are the points to consider when we start drafting a non-disclosure agreement. Okay, people who are joining for the first time, please like and subscribe to the channel, because we have one more session left that will be conducted tomorrow. So you don't miss out on tomorrow's session. Make sure that you have subscribed to the channel, and also have joined our WhatsApp group, because over there we notify you about when we are going live next and all. So subscribe to the channel and join the WhatsApp group that is there in the description of this particular live session. All right. So I believe the screen is visible to you all. Can you please give me certain reaction chat box that the screen is visible? Is it visible to you all? Make sure that you have liked and subscribed to the channel so you don't miss out on tomorrow's session, because we are going to understand about drafting. I'm going to show you the template of NDA in tomorrow's session and how the clauses will be drafted. We are going to go through several confidentiality clauses as well in tomorrow's session. Okay, give me certain reactions please, so I know that the screen is visible to you. Any your end? Okay. All right. About our major concept of trade secrets. I explained it to you in brief in yesterday's session about trade secrets. Like, what are trade secrets? Let me know, have you heard of this term before or not? Okay, do let me know. And also, if you are interested in intellectual property rights, this is going to be a very interesting topic for you. What are trade secrets? Trade secrets are a type of intellectual property rights only. What are intellectual property rights? In very brief, any type of property that you are creating from your own intelligence is your intellectual property, right? Anything that you have invented, anything that you have written, be it your song, be it movie, the person that has created it using his intelligence and skills becomes his intellectual property. Okay, now in this scenario, what are trade secrets? We might have heard of the famous intellectual properties, that is trademark, patent and copyright. We all have heard of it, right? There's one more to it, that is your trade secret. Now, what is trade secret? It's a secret, it clearly says, right? It's a secret that is helping a company earn. Okay, that is helping a company do trade. Every company have their own secret that is giving them leverage in the market, that is giving them competitive advantage in the market, keeping them ahead of all. When we talk about trade secrets, the famous trade secret that comes to everyone's mind is your recipe of Coca-Cola. If you'll visit Coca-Cola website, you'll see over there our Coca-Cola is made out of using secret ingredient. Visit Coca-Cola website today and check out over there. You'll find the word secret ingredient. What is that secret ingredient? That is their trade secret. Trade secrets are the secrets that give the company a leverage in the market, that keep their product different from the others, and that has got commercial value to it. Any type of secret that has got commercial value to it is known as your trade secret. Okay, people who are joining now, do let me know in the chat box if it refer to the last session by checking previous recording. Okay, now trade secrets are the secrets that have got commercial value, that give competitive advantage to the company. Now, when I'm talking about Coca-Cola, if you'll notice, the taste of Coca-Cola tastes different compared to your thumbs up or Pepsi, right? Each beverage have a different taste. Why? Because they all are having their own recipe over here, and the recipe of the Coca-Cola is a trade secret. When we are talking about trade secret laws, there are no fixed trade secret laws. Why? Because in order to get any intellectual property right, you have to disclose it. In our yesterday's session, I talked about patent registration. So, in order to get anything patented, you have to properly disclose step by step process of getting that invention of creating that invention, right? But if I'm talking about trade secret, it's a secret. And if I have to disclose it, it will no longer remain a secret because everyone will be aware of it. So the only way of keeping your trade secret as secret is your NDA. In order to keep a trade secret as your intellectual property, there should be an NDA between the parties. The only way of protecting a trade secret is by entering into non-disclosure agreement. Okay, so there is no specific way of registering a trade secret. The only instrument that we are left with is having a non-disclosure agreement. So you can understand the importance of NDA now. If you are the lawyer who has been selected by Coca Cola to draft a non disclosure agreement for them, you can understand how much, the weightage of NDA is over there. You have to secure the most important ingredient of the company. So your NDA should be drafted in such a manner that in no manner the other party is disclosing the ingredient of Coca Cola to any third party. There was one incident as well where two employees of Coca-Cola tried to steal their particular this thing trade secret information and sell it to Pepsi. But Pepsi instead rejected that offer and informed Coca-Cola about this incident. Accordingly, Coca-Cola took action on those employees. Okay, so that's the importance of non-disclosure agreement. That's the reason companies enter into NDA even with their employees. Now, how a secret is kept. In order to consider any information as trade secret, there are few points over here. I have a detailed video on trade secret on YouTube only. You can check out that later after session. Okay, that will provide you more knowledge about trade secrets. And if you want to learn more about intellectual property rights and to register it, we also have a course on IPR. You can check out our website for that. Now, trade secret, first thing, you should be having a commercial value. It should be a secret on which your business depends on. Third, you should be taking all the necessary precautions to keep that secret as secret. Okay, because if I'm saying that something is secret, I should be taking all the precautions to make sure that this secret remains a secret. So Coca-Cola makes sure that they have proper security surveillance, they have proper security guards, the ingredient is kept secured in a proper locker room. So they have taken all the necessary precautions to make sure that their secret remains a secret. Okay, and when they are, let's say there's a situation when Coca-Cola wants to shift their secret ingredient from their locker room to a third party locker room, in that scenario they'll be entering into non-disclosure agreement with that third party as well as with the transportation company. If they have had that transportation company again outsourced it from some other vendor, they'll be entering into NTA with all the people who are getting access to that secret to make sure this secret doesn't get leaked out. Why? If you'll notice, the price of Coca-Cola and Pepsi are also different. Coca-Cola is comparatively higher priced compared to Pepsi and Thumbs Up. Why? Because of its taste, it is demanded more in the market. And why it is getting this leverage in the market? Because all the companies are providing you same thing, right? But they taste different. What is bringing in this difference? The secret ingredient used by Coca-Cola. And if every other company also gets access to this ingredient, Coca-Cola will lose over its market leverage. It will lose over its this thing competition in the market, right? Because everyone is now providing the same product. So why I should be charging more for that? If I do that, I'll not be able to run my business, correct? So that's the importance of your trade secret. Do let me know how you found on this topic, whether it was interesting for you or not. So by way of this, we have understood the importance of trade secret, and the only way of it is by entering into non-disclosure agreement. Okay, please stay hooked to the particular series. I'll be covering more points, and we are yet to cover your obligations and exceptions of the parties. Understand more. I'll be answering to all your questions towards the end of the session. Okay, so you can also comment your questions in case the live chat gets removed. You drop your questions in the comment so that I can answer them even after the this particular live session. Okay. Now there's another point over here. This interesting point, that is your non-compete agreement. Not sure whether you have heard of it or not, but this is very interesting topic. And whenever you enter into corporate world now, do check out in your employment agreement. Does it have a non-compete clause over there? Okay. Does it have a non-compete clause over there? um, Again, there's a separate session. There are two sessions on non-compete clauses that has been uploaded on our YouTube channel. You can check out that to understand more in depth about it. To brief you out, non-compete basically means that you are not allowed to work anywhere else. Okay, why we are including this information, I'll explain this to you in form of your employment agreement, because non-compete clause or agreement you're majorly going to find when you are uh, like working for someone. You're majorly going to find this clause in employment agreements only. Let's understand this by way of your this thing, a story. Okay, let's understand a case law of Google versus Microsoft. It's not Kaifuli. I'll explain you what's the role of Kaifuli over here, but it's Google versus Microsoft. Okay, so scenario, what happened? Kaifuli was an employee of Microsoft. Okay, Kaifuli was an employee of Microsoft who was working under like a very big role. He was a computer scientist and was working as executive and vice president. He was working as vice president in Microsoft and handling a team over there. Later on, we all do this. When we get a better offer, we switch companies and all, right? So he was working in the position of vice president. He got offered by Google in the year 2005. When Google wanted to expand its business in China, they reached out to Kaifuli because he had this experience, he had required skill sets and everything. Correct? So they reached out to Kaifuli and offered him the position. Kaifuli switched to Google. Google was at this time working on their search engine, right? Google is famous for its search engine. It was working on its search engine at that time. So Kaifuli had that specialty. He was working on a similar kind of thing when he was working with Microsoft over there. So he switched from Microsoft to Google and he started working on search engine. Now, if you'll notice, Microsoft and Google both are competitors. They both are competitors in the market, right? So Microsoft filed a case against Kaifuli and Google, saying that Kaifuli is disclosing the information to Google. Why? Because he was using his skill sets that he gained while working with Microsoft. He used those skill sets to provide services to Google. Do we have any restrictions on that? He was working on similar type of project when he was working with Microsoft. Now he's using the same skill sets while he's working on Google. So, in this particular scenario, the issue of non compete clause came up. What is non compete clause? It's a clause that restricts you from joining the competitor in the market. Okay, so had there been a non compete clause in your NDA, what it would have happened? Kaifuli was allowed to join Microsoft, but he was not allowed to work or use the same skill sets. He would not have been allowed to work on the same department. Okay, so non compete basically restricts you competitors as well as from starting your own business. The purpose of non compete clause is basically when you see this clause, the company is restricting you from joining the competitor's company as well as from starting your own business. Let's take up another example. You worked in a company as digital marketeer for a period of 10 years. 10 years is a very longer period of time. You were directly dealing with clients, you were handling a team, you gained all the expertise, you learned how to run a digital marketing firm and everything. Now you decided that you want to run your own business, you want to set up your own digital marketing firm. We all do, right? At certain point, when we have gained expertise in that thing, we decide we want to start our own business. So you decided now you want to start your own business. But In this situation, if there is no non compete clause, you can simply leave your job, you can start your own business, and you can become the competitor of your previous employer. You have left that job, now you are in the market as competitor to your employer. Now there will be loss to your employer. He trained you, he paid you for 10 years, he provided you with the platform and everything. You left him and you started your own business, and you are his competitor now. In order to restrict you from doing this, what he'll do, he'll include a non compete clause. This clause will restrict you for a certain period of time only. It cannot be evergreen in nature, it will be time bounded only. It can be for a period of 6 months, 1 year, or 3 years. Okay. Now, this particular clause is restricting you for a period of, let's say, 6 months to not open your own business or not work under any competitor for this particular period of time. After 6 months, you can open your own business. Why they are doing this? Because for a period of, let's say, 6 months, your knowledge is very much fresh. You have got all the data with you, like who are the clients of the company, what the company used to work, and everything. After 6 months, your knowledge and this thing, access to the confidential information, will also be removed. Correct? So you'll not be that much aware at this time. After a period of 6 months, the knowledge will not be that fresh. So you can enter into business, but provided there will be another thing, that you're not allowed to reach out to the clients of the company or the employees of the company. Okay, have we got the basic understanding of non compete, that you are restricted for a limited period of time to not to start your own business and not to join the competitor's business as well? Are we clear? There are more things to this, but I'll not cover this because our topic is NDA. So I covered this in very brief, that you can also include a non compete clause to your NDA. The purpose of that will be to restrict you from from becoming another competitor to the company. Let me know if you have any doubt, comment section and the chat box. Okay. Okay. This period, basically, non-compete cannot be, evergreen in nature. It is always required to be time bounded. This period gets decided by the company. There is no law related to non-compete. And if you'll understand, if you'll check my other video, you'll get to know that non-competes are actually not allowed to be included in agreements, provided there are certain exceptions to it. You can include, but there are certain conditions to make it properly valid in India. Okay, companies are still including these clauses, provided that there are certain restrictions. So do check out. This is very interesting topic, and even lawyers get bounded by non-compete clauses. Okay, so just go and take a look into your employment agreement. Does it have a non-compete clause? Because in companies, mainly in MNCs, they do include non-compete clauses in their agreement as well. Move on to our next thing. We already covered laws governing NDA. Let's understand about your types of NDA. People who are joining now, make sure that you have subscribed to the channel, because we have one more session that will be conducted tomorrow. And I hope for the rest that you're enjoying the session. Do let me know in between the session as well that you're enjoying it. Give me certain reactions, okay? Let's understand about types of NDA. So there are majorly 5 types of NDA. If you remember, in our last about the this thing, how many parties are there in NDA? How many parties are there in NDA? Do let me know, people who are joining today. How many parties are there in NDA? There are 2 parties. What do we call them? We call them disclosing party and receiving party. Disclosing party is the party that is disclosing information. Receiving party is the party that is receiving information. Right? Now we'll understand types of NDA. First is your unilateral NDA. Unilateral NDA is the NDA where the roles and responsibilities of the parties are very much aligned, where one party is disclosing information and you are receiving it. So the rules are very clear. I am sharing information with you. Your responsibility is to make sure that the information remains confidential. It is not shared with any third party. That is unilateral NDA, okay, where only one party is sharing the information, other party is receiving it. Do let me know, continuously give me reaction, so I know that you are understanding each type of NDA. Okay, Let me know, give me reactions, give a fire sign, emoji, anything. So I know you are understanding everything. Next is your bilateral NDA. In bilateral NDA, both the parties are playing the role of disclosing party and receiving party. Means both the parties are disclosing information and they are also receiving information. So they are exchanging the roles and playing both the roles. Both are responsible to keep the information protected. There is exchange of promises. Okay. Are we clear with bilateral NDA and unilateral NDA? Okay, give me the actions fatafat fast please. Then we have your multilateral NDA. Multilateral NDAs, over here these NDAs are mainly entered when there are two or more parties. In order to enter into NDA you need to have two parties, disclosing party, receiving party. But in multilateral NDA we have more than two parties, so there can be 3 or 5 or 10 parties as well. Okay, why do we enter into multilateral NDA? To save time. These NDAs are mainly entered when we are entering into construction agreements, consortium agreements, partnership agreements, okay? Because over there you're dealing with multiple people, so you'll enter into multilateral NDA. In this NDA, you'll mention three parties. Each party will be playing role of disclosing party and receiving party, and they all will be responsible to protect the information that is shared by each party. So, what we are doing basically over here, let's take up an example that Manan, we have Manan as well as Aman over here. Manan, Aman, and Preeti. Okay, Manan, Aman, and Preeti. We have three people over here, and they all are doing business together. So there is one scenario that Manan is going to enter into NDA with Aman, one NDA. He's again going to enter into NDA with Preeti. So there will be an NDA between Manan and Preeti. Then again there will be an NDA between Aman and Preeti and Aman and Manan, right? Like all together there will be several NDAs. How we can bring it all together? We can enter into one multilateral NDA where we can keep all these three people as parties to that non-disclosure agreement, and we can mention their roles and responsibilities. Okay, are we clear with the understanding of your multilateral NDA? Do let me know. I hope you guys are having clear understanding of these things, because now we are going to understand about your non-compete NDA and non-solicitation NDA. Non-compete NDAs are the same. The point that I covered about non-compete clauses, right? The same thing when you're including in form in your NDA, when you're including a non-compete clause in your non-disclosure agreement, it becomes a non-compete NDA. Basically, when you are putting two restrictions on the party, one with regard to confidential information, that they are not allowed to share confidential information with any third party. Second, with regard to they are not allowed to work with the competitor. So, in your employment agreement, there will be mentioning of these two clauses as well, non compete as well as confidentiality. So that tomorrow, like in our example of Google and Microsoft, tomorrow, if Kaifuli joins Google, he is not allowed to disclose confidential information of Microsoft with Google. Okay, so these are the two restrictions. By way of including non-compete clause in your non-disclosure agreement, you are making your non-disclosure agreement watertight. There is no way that your employee will be able to disclose any confidential information with your competitor, because you're not allowing him to join the competitor anytime soon. Okay, then is non-solicitation NDA. This is very complex word, non-solicitation. What it basically means that you are not allowed to take away my clients or vendors. I'll give you a scenario over here. Again, the digital marketing firm example, right? You worked in that firm for a period of 10 years. Now you decided that you want to open your own firm. Okay, you decided to open your own digital marketing firm. So when you decide to open your own digital marketing firm, what you'll try to do, you are already in good touch with the previous clients. So when you're starting your own business, you'll try to reach out to the clients of the earlier employer. You'll reach out to them saying that, because you already had a good connection with them, right? So you'll say that I'll provide you with the same services at much cheaper price. What the client is going to do, he's already aware of how you provide services, he already had a good connection with you. He'll take away business from your previous employer and give that business to you. People do that, right? They'll reach out to their connections, and their connections, the connections you created while working under your employer, you'll reach out to them directly. So you are stealing the business of your previous employer. In order to restrict you from doing so, we are going to include a non solicitation clause, or you can also enter in form of a non solicitation NDA, where you are restricting your employee to not reach out to your clients, to not reach out to your vendors or any other contacts. Okay, so this way your business remains protected. Are we clear with the meaning of non solicitation? It is basically included so that you don't reach out to the previous employer's connections and steal them away. Non solicitation basically restricts you from stealing the connections. Are we clear with it now? Give me your reactions that you guys are getting proper understanding of it. Okay, give me any thumbs up or like or anything, so I know you guys are understanding the concepts. Now let's move on to your types of confidential information. Very, very important. Hereafter, whatever we are going to understand, be it confidential information, be it obligations of the parties, all these things you are including in form of clauses in your non-disclosure agreement. Okay? So these points that we are discussing, based on the understanding of these points, you are mentioning clauses in your non disclosure agreement. I'll show you a template of NDA tomorrow, and people who believe in purchasing templates, like you will come across posts like providing 2000 templates, 2000 drafts, or purchase drafts. Please don't do that. Don't use chat gpt, don't purchase already drafted templates and all. It will be of no use if you don't have understanding of the concepts. Okay, you're just wasting your money and time purchasing those drafts, because they are basically useless. Every scenario is different and you have to draft your NDA. As a lawyer, you have to apply your own legal mind, right? Accordingly, you have to draft your clauses as well. One important clause in your non disclosure agreement is going to be confidential information. Let's understand about confidential information by way of understanding how we are dividing information into different categories. Okay, are you guys with that? You guys are with me over here. Okay, now what is information? Information is basically divided into four categories: public, internal, confidential, and restricted. Let's understand what is public information, and I'll ask you, like, I'll give you a scenario as well over here. You have to give me answers. Okay, so be very much attentive over here. Let's I'll give you proper scenarios, so you have to answer me in the chat box about it. Okay, be very much active. All right, I hope you all are ready. So, the public information, let's understand that. Any information that you can search by way of Google search, or any information that is visible to you on podcasts or news articles is known as your public information. Basically, any type of information that is easily accessible and is available on your internet is known as your public information. Okay, we'll understand the type of informations, and then I'm going to give you a scenario. For this, I want you to be very much active, so keep your chat box open right now. Next is internal information. Any type of information that is shared with limited group of people. Not everyone is having access to any information that is shared with limited number of people is known as your internal information. For example, for example, your family. Okay, there are certain internal information of your families as well, right? Not everyone is aware of. Correct. When it comes to your name, let's take my name. My name is Ria Chhabra. That my surname is completely a public information, that is known, that is well known and everything, right? I have social handles and everything. Internal information: how many members are there in my family, my personal information, like how many members are there in my family, where like from where I am and all. an information that is with limited number of people will become an internal information. Confidential information, our main topic. Confidential information will become an information that is secret. That is a secret. Other way of confidential is secret. Any information that you are taking all the necessary precautions to share it with very limited people is known as your confidential information. Okay, so you share certain details with your best friends, correct? So the information you are sharing with your best friend might your parents are not aware of. There can be scenario. So that can be considered as your confidential information. I'm trying to come up with easiest examples. Okay. Then we have restricted information. This is your highly confidential information. Restricted information. Okay. Restricted information of which you are taking all the necessary precautions to keep it as like to keep it protected, and very few people are aware of this information. You are taking all the necessary precautions to keep this information as secret. Are others also facing issue? Are you guys not able to hear me? Do let me know. Are you guys able to hear me? If yes, give me reaction so I can continue. Or um please let me know so I'll reconnect if I'm not audible. I'm audible? Give me heart reaction or anything because someone said I'm not audible. Okay. If you're facing issues, please try to reconnect. Okay. Yeah, I was talking about restricted information. Let me just, you guys are able to see restricted information. I hope it's visible. If not, I'll zoom it more for you to quickly take a look. Okay. Restrict, it means any information that is highly restricted and very few people are having access to it. Now, information related to my health care. Okay, all the information related to my health will be considered as restricted information because this information will just be between my family and my doctor, right? So this way you can differentiate between different type of information. Any information that needs to be highly secured will be covered as your restricted information. I'll repeat it once again so guys, so you guys are ready. When I'm going to give you, certain questions, you have to let me know which under which category this information will be falling under. Let me know if you are ready. Drop it in the chat box that you are ready. Okay, then I'll come up with the scenario. I'll give you the scenario. Let me know you. I'm just revising. Public information is an information that is easily accessible in public that you can Google search and all. Internal information is information that is shared with limited number of people. Confidential information is information that is secret, that is not shared with everyone. Restricted information is the information that for which you are taking high precautions to make sure that this information is not shared with anyone. So tomorrow if your doctor wants to share your health related details with another doctor, they have to take prior permission from you because that is restricted information. Are we clear? Are you guys ready in the chat box that you are ready? Okay. All right. Let me know fast. I'll give you the scenario over here. It's coming now. Okay. Let's take up an example that you have joined a company. You have joined Infosys. Okay. You have gotten an opportunity in Infosys. Now, you are sharing with your friend. You are sharing with your friend. Your friend asks you, like, which company you have joined. Okay. Your friend has asked you which company you have joined. You shared with him, I have joined Infosys, and then you have shared about like under which department you have joined. Out of this, the name of the company will fall under which particular information? The name of the company will fall under which type of information? You have a friend under which particular category the name of the company will fall under. Come on, fast. Okay, you guys are saying it's public. Correct. Will you be allowed to share the website of the company with your friend? Will the website of the company will be considered as public information? Do let me know. Okay. Yes, it because it is easily accessible. So it cannot be considered as confidential information. You are not barred by your employment agreement saying that you're not supposed to share the name of the company or disclose the name of the company. Okay. Now you are sharing with you joined the company. Every company have their own vision and mission. Correct? They have their own vision and mission in a company. Now, under which category the vision and mission of the company will fall under? Which type of information this is? Vision and mission of the company, or the, let's say, employee code of conduct, this will fall under which type of information? Employee code of conduct, vision and mission will be falling under your internal information. Correct, this will fall under your internal information, because this information is shared with just people who are employee of the company, employees of the Infosys. They'll be having access to this information. Correct. Now, you have been, there are several departments, right? There are several teams in every company. There are several teams. You have been like let's say that the clients of the company are Coca-Cola, Pepsi, and Thumbs Up. These are the clients of the company. So in this scenario, what type of information will this be? Clients of the company, information related to clients of the company. Which particular information, which category this information will fall under? The clients of the company. Think about it, let me know faster. We have to cover obligations as well today. It will be falling under your confidential information. Correct. You are not allowed to disclose the clients of the company to anyone who is not working in the company, or even who is not part of your team. So even if people are working in same company, right, still they are not allowed to disclose the name of the clients of the company to other departments as well. There are chances that you are working in legal team, your friend is working in IT team, and you both are working in Infosys only, but still you are not allowed to disclose the name of the clients as well. That is not allowed. Okay. Now, when you have been provided access to the client system, you are working with Infosys, you are working for Coca-Cola, who is the client of the company. You have been provided access to the Coca-Cola system. Which category this information will be falling under? The system of Coca-Cola, under which category this information will be falling? Someone is saying confidential, some of you are saying restricted. Come on, fast answers. It will be your restricted information. Very correct. Majority of you gave correct answer to this. It is, yes, it is confidential and restricted, both the things. Okay. Restricted informations are always your confidential information as well. Remember this thing, it's not different. It is always restricted informations are your confidential information as well. But for this information you need to take higher precautionary methods. Okay. So when it's any matter related to client, even when Infosys is going to give you access to client system, they have to take prior permission from client before giving you this access. Okay. So any type of information for which you need to take prior consent will be considered as your restricted information. Are we clear with the types of informations now? Give me your answers in the chat box or reactions that we all are clear. Then I'll proceed ahead. Come on, faster. Are we clear? Okay. Just give me a second. I'll just pause for a few seconds. Okay. Now, the importance of confidential information. Why we discussed about types of confidential information throughout. Reason is, in your NDA, you have to define what type of information will be considered as your confidential information. Reason is, tomorrow if you are entering into NDA, you cannot bind the other party saying that whatever information I've shared with you will be considered as confidential. So if I'm saying this is very vague. Reason is, you are if whatever information, that means the name of the company, the website of the company, the employee ID, everything will be covered under confidential. That even if the information is out there in public domain, if I'm saying that information is confidential, do you think that is fair? If tomorrow Infosys comes and says that why did you share the website of the company with your friend? That was a confidential information. Do you think that will be fair to do so? Do let me know your answers. Okay, that will be fair or not fair. If Infosys can come up to you, say that you were not supposed to share the website of the company with your friend, they cannot say this because this information was already out there in public domain. So this was not a confidential information, it was easily accessible, so this will not be fair. That's the reason you have to clearly define what type of information will be considered as confidential information. Okay, so this is how you define confidential information. You have to be particular about which information will be considered as confidential. So how you'll frame it: information with related to your client data, vendor data, email lists, all will be considered, or any other client related information will be considered as a confidential information. Okay, in our contract drafting courses we go more into depth while covering each clause. We provide you proper understanding of the things. So the batch is also starting from 10th January. If you want, you can check out that on website. It will cover more other agreements as well. Okay, let's understand about your obligations of receiving party. We are clear with confidential information, right? We covered about how and what is the importance of defining confidential information in your NDA. Okay, tomorrow I'm going to show you confidentiality clauses as well to have a better understanding of how do we draft confidentiality clauses for each agreement. So I'll showcase you several examples from employment agreement, from client related agreements and everything, and I'll give you proper chance to go through those agreements as well so that you can have proper understanding of it. Okay, now let's understand about your obligations of receiving party. Before I proceed ahead with this, maybe the session might get extended a little bit, and do let me know in the chat box if you have any questions or doubts. I'll answer them all. Okay, uh, or you can drop them in the comment box, so in case if I miss out on answering them in the chat box, I can reply back to you in the comment section. Let's cover your obligation of receiving party. A very, very important clause to be included in your non disclosure agreement. This clause is talking about what will be the responsibilities of the receiving party. Who is the receiving party? The party receiving the confidential information. About how he is required to secure the information. Confidentiality. That is very basic thing. We are entering into non-disclosure agreement for the purpose of keeping the information as confidential. So our ultimate purpose will be to keep the information as confidential. So the first responsibility of the receiving party is to maintain confidentiality of the information. That means not share it with anyone. Okay. Next is use limitation. Very important thing. Use limitation. Use limitation basically is saying that you are required to use that confidential information only where it is required. Okay, let's take up an example. You have been given access to the client system. You are a lawyer, so you have been given access to the client system. Why you have been given access? So you can work on the contracts. Okay, you can do your, like, you can perform your job responsibilities and all. So you have been given access to the system, so you can work on the contracts. Now in the same system, accounts team is also working, IT team is also working. So you have all the data, all the company data in that system. You are working on that system as a lawyer to work on the contracts. Now if you're going ahead and working on the accounts as well, you're checking out people's salary in that system, that will not be considered as valid use of confidential information. Correct, because you were not authorized to do that. There should be use limitation. You are only required to use that information when it is required and where it is required. Okay. Next example is protection of information, another responsibility. When you are being handed over a confidential information, your responsibility is to protect that information as your own. So whatever points I'm discussing, you'll be including these points in form of clauses in your non disclosure agreement. You can keep a section obligation of receiving party. Under that section we are going to cover all these points, whatever points I'm going to discuss, right, I'm discussing right now. We are going to cover all these points in form of clauses, and we are going to explain them. So when I'm saying protection of information, you will further elaborate it saying the receiving party is expected to protect the confidential information shared by disclosing party as if it's its own information, and take all the necessary precautions to protect the confidential information. Okay, so you have to clearly give the responsibility of protection of confidential information to the receiving party. Let's take up another example over here. When, let's say I'm going out of the town, i I am giving my cycle to my friend saying that till the time I'm not in town, please you can use my cycle, please take care of my cycle. Okay, now, during this time, it will automatically become the responsibility of my friend that he needs to protect that cycle because I have handed it over to him. So, when I'm not in town, my friend is required to keep that cycle properly locked, keep it at somewhere internal so it doesn't get stolen or anything, right? So, all these responsibilities will be there with my friend. Same way, when I'm sharing any confidential information with you, it will become your responsibility to protect that information, take all the necessary precautions. That's the reason companies make sure that they have proper surveillance cameras, they train their employees, they properly take trainings and everything in order to make sure that the information remains confident. Okay, are we understanding everything so far? All right. Next was engineering. The purpose of this point is that if I'm sharing the information with you, you are not taking that information against me. Okay, basically, let's say that I have shared an information with you with regard to particular this thing invention I'm working on. Okay, we have entered into non-disclosure agreement for that as well. I've shared. I'm working on a project. It's not yet launched in the market. So, what you are doing, irrespective of the NDA, you are claiming this information as your own, and you have launched it in the market. So you have taken it against me. You have titled that particular thing, you have taken it against me, you are claiming my property as your own. Okay, so that is your no reverse engineering. You are not going to take up this information and use it against me. Okay, this is one thing. We'll connect this thing to the last point, that is no transfer of ownership. So a separate clause will be included in your NDA that is going to talk about in no manner the parties are transferring ownership of the confidential information by entering into this NDA. And the purpose of this clause is simply saying that by way of sharing this information, in no manner I am giving you the ownership of it. So when you are heading out of the town and handing your cycle to your friend, are you transferring the ownership of it? No, right? You are just giving him access to the cycle for a limited period of time for few days till the time you are not there in town. Once you are back, you are going to take up that cycle again, right? You're going to take it back. Same is with your NDA, confidential information as well. By way of sharing the information, you're not giving them any ownership to that information. Are we clear? Are you guys able to understand? So, okay. So let me know in the reactions. Your reactions have stopped. So please let me know you guys are able to understand. Okay. Now, next is your return or destruction of information. Very important point, and this will be covered in form of a separate clause in your non-disclosure agreement. Okay. Do let me know you guys are there with questions. Come on. Um, yeah. Return or destruction of information, it basically means that how you are supposed to return the information. There's a term to your NDA. Your NDAs are for a period of 2 years or evergreen. Okay. Once the NDA is over, how you are supposed to return that information. So let's take up an example that you enter into a project for a period of 2 years. After 2 years, the project is over. That means NDA is also over. Correct? Now, you are no longer related to the party. So, what will happen to the data that you shared with them? You are no longer taking up their services. What will happen to your data? Let's say that you hired a digital marketing firm, you provided them with your client data to reach out to your clients. Okay. Now, after 2 years, you have ended your contract with the marketing firm. Okay. Now you want to like switch to some other firm. In this scenario, you need your client data, right? Because it is no longer useful for this digital marketing firm, and if they still have got access to this data, they can sell it to some other competitor as well. Correct? So what you'll do, you'll take up this data from the digital marketing firm. You'll provide proper step by step process of how the data will be destructed, how it will be returned back to you once the contract is over. So you'll provide step by step process of destruction of information, that once the term is over, the receiving party is required to destruct from all the digital records the trails of confidential information. They have to hand over all the electronic gadgets or documents related to that confidential information to the disclosing party. Okay, so you'll properly provide step by step process. If you had provided them information by way of pen drive, you are required like you can include a line saying that all the pen drive hard drives will be returned back to the disclosing party once the NDA term is over. Okay, so this way you're going to provide explanation of return or destruction of information. Then we have notification of unauthorized disclosure. Very important clause, notification of unauthorized disclosure. This clause is basically talking about your responsibility as a receiving party to notify to the disclosing party that they are required to inform you that the information has been leaked out. Okay, I'll explain this to you in form of an example. When you're working with a company, a software proper, you have been trained on. Okay, you are properly trained on what things you can do and not. So you have been properly trained that you're not supposed to use hotel wi-fi or public place wi-fi, because that will increase the chances of computer getting hacked. Okay, now let's say due to certain emergency situation, one of the employee logged in using public wi-fi. He logged in using public wi-fi. That way his laptop got hacked. So once the laptop gets hacked, we all know we are working digitally, so all the information is there, right? If his laptop gets hacked, the hackers will get access to your client data, and this way the client data will be at risk. So as a company, it will be your responsibility to inform your client that there has been like unauthorized disclosure, so that they can take all the necessary steps from their end. So you'll be informing your client company. What they'll do, they'll block all their accounts, they'll notify to their further clients, they'll inform their employees that if they receive any link or any mail, external mail or any phishing mail, kindly do not open that, because that can be sent by hackers, right? They can further block their systems, so it is properly protected. That is one of the duty of the receiving party, that whether it was unintentional, still you have to notify to the owner of that information that there has been unauthorized disclosure of the information. Are we clear so far? Are you guys able to understand everything? Do give me your reaction so I know you are there, you are understanding the concepts and everything. Now, next is your limited access. Another responsibility of your receiving party is to give limited access. Why is it so? Because when do you think it will be fair that you are a lawyer who's working with the under like Coca-Cola team? Okay, you are a lawyer working in Coca-Cola team, and there are several other clients of Infosys as well, Pepsi and Thumbs Up. Okay, they are also the clients of the Infosys. These are just hypothetical situation. Okay, so you have been given access to the system of Coca-Cola and Thumbs Up as well. You're not working on these systems. You are working in all together Coca-Cola team, but still you have been given access to the Thumbs Up and Pepsi systems as well. That is not required. That is one of the responsibility of the receiving party, that they are required to give limited access to the people only where it is required, not giving access unnecessarily to everyone. Okay, so these are the basic obligations of the receiving party. Are we clear? Better understanding of this thing? Okay. So I wanted to cover exceptions of receiving party as well. This is very interesting. Okay. You guys are going to love understanding this concept, but I'm going to cover this in tomorrow's session because I think so for today it's a lot of knowledge. So we'll cover this in tomorrow's session. I'll also show you uh, like several set of clauses, and I'll take you through the template of non-disclosure agreement and how to draft it. I'll probably showcase you everything. So make sure that you have subscribed to the channel so that you'll be notified. Tomorrow again at 8:30 p.m. we are going to go live and cover about drafting a non-disclosure agreement. Okay, so make sure you are there, you are marking your attendance, and do share if you're liking the sessions, do share it in your college groups or with your friends who would love to attend, because tomorrow's session is highly important. Please go through yesterday's session. If you are someone who is joining the session for the first time, you can refer to our first session where we covered about your non-disclosure agreement. Okay, so now we are open for questions or anything. Do let me know in the chat box. All right. Okay. And of course, if you like the session, please do give me a thumbs up, give it a like, and share it with your friends, comment, and everything. It keeps me motivated as well, so that we can come up with more such sessions for you. If you have any suggestions from your end on which topic next we should be covering classes, then also do let us know in the chat box or comment, so that we can properly conduct those sessions for you. Okay, and for more, if you really like the sessions and want to learn more from us, I conduct contract drafting sessions in our LeDroit portal. You can visit the website and register for the contract drafting course, where I'll probably take you through how to draft a contract, review a contract, negotiate a contract, and what type of questions you can expect in your interview. I'll make you proper corporate ready. Okay. All right. So, yes, for each agreement, there's a separate format. In our courses we share with you proper formats of those agreements as well. We explain you what are the clauses to be included in each agreement. So each agreement differs, each agreement requirements are different. You need to understand like what are the things required. Like when I'm talking about NDA, if you if you attended our yesterday's session, in NDAs are of zero value, right? So the clauses are completely different. On the other hand, if I'm talking about your purchase agreement, I'll be mentioning amount over there, I'll be talking about pricing over there, right? So this way all the agreements differ. You have to analyze the situation. Your agreements also differ based on the requirements of your client, and accordingly you have to draft these agreements. Okay, so we cover all these details in detail in our contract drafting session by taking you through several agreements. There is a limited liability partnership agreement, joint venture agreement, franchise agreement, employment agreement, freelancing agreement. Okay, so there are activities as well where you'll be having a proper contract negotiation session, where you'll be getting a chance to engage with other students and do a proper negotiation activity. You'll be provided with feedback on your agreements. So in our YouTube session, it's not possible to give you feedback, but in our live classes, we give you assignments where you draft and we review your assignments and give you feedback on your performance. So if you want to join, you can check out our website for that as well. We have other courses like mergers and acquisitions, intellectual property rights as well, where you'll be learning step by step registration of IPR. When I'm saying mergers and acquisitions, you'll be learning how M&A deal take place in companies, how to do due diligence, how to prepare the due diligence report, and all the courses are conducted by professionals. So you'll be understanding proper practical knowledge. We cover everything from basics, so irrespective of whether you are in first year, second year, or whatever year you are in, you'll be understanding everything in detail. Trade secrets can be protected by NDA or can I register in government? I already mentioned this point. Trade secrets are only protected by way of NDA. There's no act related to your trade secret. We have Trademark Act, we have Copyright Act as well as Patent Act, but when it comes to trade secret, the only way of protecting your trade secret is by way of entering into non-disclosure agreement because they are not registrable. It's a secret. If I'm disclosing it, it will no longer remain a secret. Okay, so the only way of protecting it is by way of entering into NDA. Any other questions? Okay. Apart from this, like if you're joining the session later on, you can drop your questions in the comment box. I'll make sure that I'm answering to all your questions. Just a quick reminder, if you like, we covered about non-compete clauses and non-solicitation clauses as well, right? We also covered talked about trade secrets. So there's a separate session on YouTube. You can check out that as well. With regard to non-compete and non-solicitation clause, there are two sessions for the same. There's a separate session on trade secret. You can check out that to have a more in-depth knowledge about these concepts. And stay tuned for more. We'll be coming up with more such content. And of course, do let us know your suggestions. How did you find the session? Do give us a thumbs up, like, and subscribe to the channel for more such insights. And also join our WhatsApp group to stay updated. And of course, check out www.ledroitindia.in for more such courses and to have a direct interaction with the faculties. Okay, thank you everyone for joining. Hope to see you all tomorrow at same timing, 8:30 to 9:30 p.m. Thank you very much. Jai Hind. Bye bye.